All right, so why should I give him 5 years? Because the complainant in this case is the same complainant that he has the new case on.
He walked into the courtroom with a deal for 5 years, thinking this was all just a formality. He was wrong. This is Juan Carlos Aguirre Jr., a man accepting a plea deal for assaulting his partner. The prosecution has signed off on it, and his defense attorney believes it's a win. But they've all overlooked one devastating detail from his past, a detail the judge has just spotted in his file. You're about to see the exact moment she unravels their entire agreement and delivers a verdict no
2025 CR 01152. Could I have parties announce?
Your Honor, there's also the MTR.
Yeah, I'm gonna take this up first.
Can we do the MTR first?
Why are we doing the MTR first?
For purposes of the plea on the waiver and this, they're gonna be running concurrently the sentences.
I can still say it's running concurrently.
All
All right.
right. Sorry, Rick Payne for the state of Texas.
Donald Wilson for the defense.
And are you Mr. Aguirre?
Yes, ma'am.
Counsel, you received all discovery?
Yes, I have.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Aguirre, did you review the waiver of indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes, ma'am.
All right, your attorney has certain rights. He has the right to have the passage of 2 days upon the presentation of the information, and he has the right of 10 days to prepare for trial, and you have a right to have a grand jury hear the evidence in this case and make a decision on whether there is sufficient evidence to hold you over for trial. Do you understand?
Yes, ma'am.
By entering into a plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea today?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the felony information with your attorney? Did you understand it?
Yes, ma'am.
Counsel, you're waiving the reading?
Yes, we are.
State, and you're proceeding as the information is presented?
Yes, we are, Your Honor.
Mr. Aguirre, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
By information, you're charged with assault family household member with a previous conviction. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
You see this whole do you understand routine from the judge? That's not just boring legal talk. That's the court making absolutely sure he can't come back later, claiming he was confused. Waiving his right to a jury trial? That's the judge getting his signature on the all sales final policy. Every yes he gives, another nail in the coffin of any last-ditch appeal he thinks he might have.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, sir.
Mr. Aguirre, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand if you're not a U.S. citizen, you can be deported, not allowed re-entry, and denied naturalization?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. The state will take in consideration 2025 AL 006681 and 2025 PF 31338. And this will run concurrent with
I have the case number.
2020 CR 12202. Did you understand that to be the plea?
Yes, ma'am.
So now he thinks he's got this 5-year plea bargain locked down. A little naive, right? That deal his lawyer made with the prosecutor? It's worth less than a politician's promise. It's a suggestion, nothing more than a pinky swear. The judge is the only one in the room with real power, and she couldn't care less what the lawyers agreed to.
Defense,
Yes.
state,
There is, with the exception of, I had put restitution, should there be any, I know that he would be entitled to restitution here.
all right, it's gonna be restitution if any. Let me just tell you, if they're sending you to prison and your counsel is waiving a PSI, then whatever that restitution amount that that person claims, that's gonna be the restitution amount. And when you're up for parole, they'll take it up with parole. Do you understand?
Yes, ma'am.
All right, restitution, if any, to Anessa Nicole Guerra. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated primary custodial parent?
Yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
By signing that I'm sorry, not appeal. Did you review the paragraph entitled Waiver of Appeal with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, at this time, state orders into evidence, it's Exhibit 1 with all attachments.
No objection, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendants? I'm sorry, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call and the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, was kind of a tough decision for Mr. Aguirre to come to, but he thinks it's in his best interest, and he would ask the court to go along with the plea bargain that it's taken us quite some time to negotiate, but I think he wants to get this behind him. It's unfortunate that we've ended up here, but I think he is ready to move on and become a productive citizen once he gets this behind him.
All right, the court is going to sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Anessa Nicole Guerra. There's a $1,500 fine. State is taking in consideration 2025 AL 006681, 2025 PF 31338. And this will run concurrent with 2020 CR 12202. And there's to be no unsupervised contact with minors. Is there anything else with regards to sentencing?
No, no.
No, Your Honor.
Just that whenever we're finished with this and the MTR, we have the victim present who wishes to do victim impact statement.
Okay. All right, we're proceeding with 2020 CR 12202. Did you review the motion to enter adjudication of guilty and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Juan Carlos Aguirre Jr. who was placed on deferred adjudication in 2020 CR 12202
Yes.
for the offense of assault, family choking, strangulation on March 3rd, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
And here's where the whole thing goes completely off the rails. This new assault is only half the problem. The real kicker, he was already on probation for attacking the very same woman. Pleading true to violating that, that's like getting caught with your hand in the cookie jar when you're supposed to be hosting a diabetes convention. It just gave the judge all the ammunition she needed.
All right, State.
Yes, Your Honor, violation of condition number 15. On or about the 12th day of May 2021 in Bexar County, Texas, the defendant, Juan Carlos Aguirre Jr., did then and there fail to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited battering intervention and prevention program, in violation of condition number 15.
How do you plead to that? True or not true?
True.
State will waive the remaining violations, Your Honor.
Any objection?
Object.
Did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 15?
Yes, ma'am.
Court will find violation of condition 15 true. Is there a proposed agreement?
There is, Your Honor. That is to revoke the defendant's probation, adjudicate him guilty, and sentence him to 5 years TDC.
All right, so why should I give him 5 years? Because the complainant in this case is the same complainant that he has the new case on. And so why should I do this?
The lawyers say 5 years. The judge looks at them like they've grown a second head, and she asks, why should I do that? You can see the defense attorney's soul leave his body. He starts doing a little song and dance, talking about some battering intervention program. His client almost finished. Almost. That's like telling your wife you almost didn't wreck the car. It means absolutely nothing.
Judge, if we're speaking about this probation, this deferred adjudication, Mr. Geary was doing the things he was supposed to be doing at the time. He was enrolled in BIP. In fact, if you look at the records, I believe he did all but 4 classes of the BIP. But because of other circumstances, the MTR was filed on him, and he did not complete it. There was some other things going on in his home life and stuff. I believe had some family health issues and stuff, but he was doing the things he was supposed to be doing. He just didn't complete it because of the circumstances. So that makes him not a good candidate for probation. But I don't think to punish him in excess for something that's occurred after this probation expired is fundamentally fair on the original deferred.
No, I mean, because he hasn't learned anything. And I don't know what's happening in his relationships, but it doesn't appear he's learned anything. And I don't know why I should sentence him to just 5 years when he's been sentenced on an assault family household member with a previous conviction, which means there's a previous conviction, and it's against the same complainant that he's on probation for. State, why should I give him 5 years?
It just seemed that in the best interest, considering, yes, it's the same victim, but for efficiency of judicial purposes for both cases to run concurrently together.
All right, this is what the court is going to do. The court is finding 15 true. The court is going to grant the motion, find you guilty, revoke, sentence you to $1,000 fine, time and money run concurrent. There's an affirmative finding of family violence. This will run concurrent with 2025 CR 011524. There should be no contact with Anissa Guerra. There should be no residing in a household with minors. There should be no unsupervised contact with minors, and the court is going to sentence you to 8 years in the prison.
See, the judge is no fool. She sees the pattern. You assault the same person, get a break with probation, and then you go and do the exact same thing again. That's not a mistake. That's a habit. So that 5-year deal everyone was so proud of, she tore it up and set it on fire. The lawyers wanted 5, she gave him 8. Why? Because this wasn't about a deal anymore. This was about judicial discretion, plain and simple.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, for the most
You
part.
do have a limited right to appeal. That right to appeal is that as it relates in the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're gonna have to start making better decisions. Otherwise, you're gonna find yourself in and out of somebody's prison. You understand?
Yes, ma'am.
And your relationship with her is over.
Oh,
You
yes,
understand?
ma'am.
All right, good luck to you.
So, in the end, Juan Carlos Aguirre Jr. walked into court with a 5-year deal and walked out with an 8-year prison sentence. He thought he had a path forward, but the judge closed the door. Was this the right call? Or did the judge let her personal feelings override a deal made in good faith? And more importantly, does a longer sentence actually create justice for the victim? Or does it just create a more resentful man who will eventually be released? Drop your thoughts below.
So no PTI?
No PTI.
She knows about it, right?
Yes. Oh, I'm sorry.
Good morning, Ms. Hutcherson. It's Hutcherson. So you no interest in doing the PTI program?
She's currently in the PTI program. She's terminated.
Oh, she was removed? Oh,
Yes. I didn't have a.
got it. No, yeah, too late. Okay, so Ms. Hutcherson, you've worked out an agreement where they're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand, ma'am, yeah, I just see that removed. You need to understand that this DWI will go on your record. It's going to be there for the rest of your life. You need to understand that if you ever get pulled over, an officer's going to look at your history. They're going to see this DWI. If you smell like alcohol or dope, it's not going to go well. You know, the other thing, what we're doing today, it's not going to, I mean, you're looking at a minimum of 30 days in jail from now on for whatever you pick up. So no more proverbial slaps on the wrist. You understand? You're giving up the right to a trial, right to compel witnesses, testify on behalf, and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will stay on your record. You can never take it off. This is what you want to do. How do you plead to the offense, ma'am? Guilty or not guilty? I will find you guilty. I will send you to the agreement. What do you do for a living, ma'am?
I work as a receptionist.
And how much money do you make?
I bring home
I want you to understand something, ma'am, that, you know, DWI is big business. There's a $3,000 surcharge that usually is tacked on when you pick up a DWI. And when you get a second DWI, it's a $6,000 surcharge. And if you don't pay it, you go to jail for every $100 that you owe. Do you understand? I will waive your fees now. It's next time, it's around $7,000 you're going to be walking out. So if you want to get lit, just don't get into a car. $20 a button will take you anywhere you want to go. All right. Good luck with you.
Thank you, Judge.
Run it. Oh, I have to suspend your license. I'm suspending it for 180 days. You are Aziel Gracia.
Sir.
Mr. Gracia, so
He's charged with, I've never seen this before, Judge, but he's charged with violating a bond condition.
yeah, I mean, I've certainly seen it.
And,
It's either
It's not a protective order, it's a bond condition.
right, because they can't make the protective order case because it's been more than 61 days,
Had
right?
nothing to do with the protective order, Judge.
So, yeah, right, I get it.
It was a different situation completely. Had nothing to do with family violence.
Get there. So you're charged with violation of a bond condition / protective order. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. If you cannot afford a lawyer will be appointed to represent you. So before we start, was he in a PTI? Is that why this case is 1,000 days old?
Yes, sir. He just has a few BIP classes left to finish the PTI.
Okay. Okay, go for it.
Judge. The officer was dispatched to a business in Harris County, Texas in response to a disturbance. Upon arrival, the officer observed the defendant grab another male aggressively, and the officer conducted a search on the defendant's person and found a loaded gun in the front pocket. The defendant is currently on bond for an assault, family violence, and has bond conditions in place prohibiting from possessing a firearm.
Yeah, all right. Mr. Gracia, I'm going to find that there's probable cause to go forward on the bond conditions. State, what's your position as far as he's in a PTI? He's now picked up a new case. Mr. Gracia, I want you to know that we take these bond conditions extremely serious.
Sir.
You don't, though. This is not your first VPO. This is not your first violation of bond condition. You don't get it. No means no. Doesn't mean maybe. Doesn't mean I'm going to a high crime area. No means no. And now there are consequences. Stephen.
Judge, can I tell you a little bit about the case?
Sure.
You know, like, just to explain to you what happened. He was at his business. He owns a trucking company. He hired somebody who he said he took a chance on him because he's has a sketchy record, convicted felon. It didn't work out within a couple of days. So he ended up firing the individual. The individual refused to leave the premises or refused to accept it. So he started threatening him. He went inside. The individual started trying to damage the trucks. So at that point, he was fearful. He went and retrieved a firearm that he knew was hidden in the vehicle. I'm sorry, in there. I understand, Judge.
It's about the worst thing that you can do. Imagine if you use the firearm. Who gets charged with murder, Mr. Gracia? Who has now dug themselves into a potential 50-year hole? We have a case like that today where a meager argument, someone who's charged with assault is now charged with murder because of a silly ass, stupid ass argument. Now dude is sitting in custody with a $250,000.
And he's been punished at this point, Judge. He's been punished for violating the bond by getting an entire new case on that. So as far as him going into custody for violating the bond condition, I would hope that you would take that into consideration, the fact that he has gotten punished on the bond violation already, and the fact that he's already had to hire a new attorney for two cases at this point, and it's probably going to affect the other case. So I would hope that you would continue supervision on that, just taking that into consideration.
I truly appreciate your position, but you have an assault from 2019 of a family member. The following year, you pick up a violation of a protective order or bond condition. Now you have another assault that they were even, what the hell you're looking over there? Was it Jesus over there? You already have an assault of a family member that was dismissed as it is. You were lucky enough to even have this kind of an agreement where they're willing to dismiss a second assault of a family member, and now you pick up another violation of a bond condition. Eric, he doesn't get it.
I understand.
You don't get it. And now I have to show you we mean business. I think that you are utter and complete danger to public safety.
This is the line you never want a judge to say about you. When a judge calls someone a danger to public safety, that's not emotion. That's a legal conclusion. And it changes everything. At this point, past explanations don't matter. Good intentions don't matter. And even sympathy runs out. The court is no longer trying to correct behavior. It's trying to prevent the next headline. And here's the uncomfortable question for everyone watching. How many warnings should someone get before the court is forced to step in this hard? Because once a judge reaches this point, there's no room left for second chances. Only consequences.
And I will do everything in my power to protect my public in every single way. Because the last thing I want is you to pick up a murder case like we have here this morning. Someone else goes with you.
One more thing. There's a bond condition on there that he's not allowed to return to that address. That address is his business. It's his place of business. The other person has no right to that address. So he hasn't worked for the last week and a half because there's a bond condition, I'm assuming from the magistrate, that doesn't allow him to go back to that business.
Show me proof.
I'd like to be
Show
able
me
to take
proof.
that.
And, the proper, and you need to advise the proper way to do things is you call the cops. Really. I mean, that's, if you own the business, you show it. I mean, how easy would it have been to just call police?
I mean, he has a right to defend his property and
not while the case is open. He does, but not in that manner.
It's one of those things where things happen quick and you have to make a decision. When we're talking about trucks that are worth hundreds of thousands of dollars and things like that.
911, man, really?
How long did it take to get there, Judge? So
Okay, they will still take his ass to jail and then, try to get restitution or whatnot, but
So as far as the bond goes, can you set him a bond today? So
of course.
And Judge, we've contacted Conrad because it's his case, but I just want to confirm that bond has been revoked for his prior case. Is that correct?
Yeah,
Okay.
yeah, on the assault, I'm revoking it.
Yes, Judge.
Looks like they set the bond at 20,000 on the new case.
Yes, Judge.
I'm gonna mirror it.
Because he's already posted that bond, he's already hired me. He hired me on the other case as well. There's a motion to sub in your queue that I need you to sign as well.
I'll sign it for you.
I'd ask that you set that new bond at $500. It's tough for the family, Judge. I mean, at this point, he hasn't worked in 2 weeks. He's trying to get back on his feet. He did everything properly. He didn't go back to the location because of the bond condition.
I'm not doing $500. I mean, I was thinking that was gonna mirror the same one. I was gonna put it at
And that would be a
20,000.
state's position to mirror.
So he understands that we mean business, if he's unable to bond out, I'm always willing to talk after a couple of days, but I want him to understand that we take it absolutely serious. So when you go over there with a gun with the intent to do some serious damage, hell no, no way, no. And I think that making it 20,000, what the other one is, hopefully it'll get his attention.
Okay, would you
But like I
consider
said, look,
10,000?
like I'm not out for blood, Eric, so if he's unable to, after some time, come back, and I'm not talking weeks, but a couple of days, so he realizes that we mean business.
So we're talking about 2 weeks minimum. So would you consider doing 10,000?
Well, remember, I Zoom, so you can be in Abu Dhabi. I'm still, here.
His mom's present, so let me talk to her.
Yeah, for sure. Okay. You were Samuel Torres. Mr. Torres, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On November 14, 2024, the officers observed the defendant's motor vehicle make a wide right turn at an intersection with a dividing concrete median, accelerate at a high rate of speed from the intersection, failed to maintain a single lane, moving halfway into the center lane before returning to the outside lane, cross over a solid white line into a bike lane before returning to the lane, and the officer observed other cars in the area at the time, rendering the failure to maintain a single lane dangerous to the other motor vehicles. The defendant's motor vehicle stopped at a red light and remained stopped after the light turned green, obstructing traffic, and the officer then initiated a traffic stop once the defendant's motor vehicle finally proceeded through the intersection. The officers had to travel approximately 0.5 miles from the original location as the defendant continued to drive. The officer made contact with the defendant, the driver, and the officer observed bloodshot eyes, an odor of an alcoholic beverage, and the defendant stated he did not immediately pull over because he lives at the apartment complex where the traffic stop was eventually performed and did not want his vehicle towed. The defendant stated he was coming from his sister's house, and the officer observed the defendant using the motor vehicle to regain balance. The defendant stated he had one Long Island liquor drink that he was currently consuming inside the motor vehicle, and the officer found a frozen daiquiri still frozen and half consumed on the passenger side of the floorboard.
So he's drinking while driving?
Yes, Judge. And the officers performed standard field sobriety test, HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to breath. The results were 0.151 and 0.160.
Mr. Torres, do you have a Texas driver license?
Yes, sir, I do.
I'm now taking away your privilege to drive. You are not allowed to drive at all for any reason. And I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing up to 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes,
From
sir.
now on, you'll be taking the Dodge Patas. This is an affidavit that you're going to be signing with me today, promising me. And I don't care what your excuse is. If there's a burning building with 50 kittens you have to save, you get into a car and drive, we will have issues. I'm also ordering you not to consume alcohol or illegal drugs. I will randomly test you. If I find that you consume alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail. You will not get any more PR bonds, sir. Any priority to be eyes, Alex? old are you, sir?
Mid-30.
What do you do for a living?
I'm a mechanic.
How much money do you make a month?
About 24 right now.
Who do you live with?
My wife, my sister, my daughter.
Who else in the house works?
Just me.
Apply for an appointed lawyer, sir. So help me. Any issue, Mr. Torres, if I set your bond $5,000 to $10,000 and you ain't got anyone to pony up that kind of money, you will be stuck like Chuck until this case is over with. Make wise decisions while you're out there, because if you don't, I'm going to keep you. Do you understand?
Yes, sir.
Okay. Do you mind giving me an application, please? Have an application for an appointed lawyer. I need you to fill out everything. Don't just put zeros, because I'm going to send it right back to you. I'll have you sign a reset with Victoria. You're going to have to meet with Felicia for your bond conditions. Then we'll have you take a seat in the jury box.
Vasquez, Guillermo.
Jaquan Peterson.
Yes, sir.
Mr. Peterson, you're charged with reckless driving. You're facing up to 30 days and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 14th, 2024, the officer was part of a task force with the main focus being hostile street takeovers and racers. A large group of motor vehicles were meeting at the 11700 East Freeway in a parking lot in Harris County, Texas, when the officer observed the defendant's motor vehicle enter an area of the parking lot and begin to spin his...
Si tú hablas, te pongo en la cárcel. Okay, sorry, please.
Would you like me to start from the beginning, Judge?
Please.
Yes, Judge. On November 14, 2024, the officer was part of a task force with the main focus being hostile street takeovers and racers. A large group of motor vehicles were meeting at the 11700 East Freeway in a parking lot when the officer observed the defendant's motor vehicle enter an area of the parking lot and begin to spin his rear tires with a loud screeching noise. The defendant's motor vehicle did several donuts, losing control of the rear end within 10 to 15 feet of other motor vehicles, making up the pit. The officer observed the defendant's motor vehicle complete approximately 2 to 3 donuts, and a traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant, and the defendant admitting to doing donuts.
Run his NCIC. Does he have any other cases like this by chance?
I'll run his NCIC, Your Honor.
Please. Mr. Pearson, I'm going to find that there's probable cause to go forward with your case. Can you imagine if you start doing these donuts, you hit and kill someone? Who gets charged with murder? These are things you must consider when you're out there in the free world. You think before you act, think before you speak, because actions may be your last.
And Your Honor, he has no other open cases or criminal history.
Do you have a Texas driver license? Do you have liability insurance in your name? Can you run his license, please?
Eligible, Your Honor. I'm
ordering you as a condition of your bond not to participate in activities like this again. No reckless driving, donuts, street takeovers, racing. If I find that you do, the first thing I'm going to do is take your privilege to drive away from you. And the next thing I will do is I will put you in jail. Do you understand?
Yes, sir.
610. The freeways, toll roads, parking lots. This isn't the right way to put. You don't do this over there. And I'm going to tell you now, the Texas legislature has made it extremely easy for DAs across Texas to seize and take cars for individuals who participate in these types of actions. And I've had defendants come here with their cars seized, $50,000 trucks taken because of these types of actions. So be careful out there, because not only can you next time go to jail, but you may lose that very car that you had. Can you file those conditions, please? No donuts, reckless driving, etc. We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. After that, we will have you take a seat in the jury box while we get your bond condition. We'll have you sign it, and then you'll be free to go. When you come back, please have a lawyer, sir.
Potter. Page 16.
Robert Potter. Mr. Potter, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 17th, 2024, at 1:10 a.m. in the morning, officers conducted a traffic stop on the defendant's motor vehicle after observing it traveling at a high rate of speed, 67 miles per hour in a 45 mile per hour zone. Upon contact, the officer observed the defendant to be the driver and sole occupant and observed him with slurred speech, strong odor of an alcoholic beverage, and bloodshot, glassy eyes. The defendant admitted to drinking and scored himself as a 5 on a 1 to 10 intoxication scale. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 7 out of 8, 1 leg stand 2 out of 4. The officer observed the defendant to be disoriented, drowsy, had slow and sluggish reactions, was uncoordinated, unsteady, as well as disoriented during the tests. An inventory search of the defendant's vehicle revealed a 12-pack of 12-ounce Modelo's in the back seat, as well as a 6-pack of 14-ounce Michelob Ultra with 1 container left. The DICs were read and the defendant consented to breath, the results being .097 and .099.
Is there any evidence that he's consuming while he's driving?
No, Your Honor.
Mr. Potter, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license? Do you have valid liability insurance?
Yes, sir.
In your name?
Yes, sir.
Are you sure? Can you run his license, please? Any priority to eyes?
No, Your Honor.
I'm ordering you as a condition of your bond, Mr. Potter, not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, unprescribed controlled medication, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
How old are you, sir?
19.
What do you do for a living?
Gold maker. Work.
How much money do you make a month? We're going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. I'll get you with Felicia for your bond conditions. And after that, you'll be free to go. Be careful. Don't use. I don't care what your excuse is. If I find that you're using, there's a one-way trip. You understand?
Yes, sir.
Okay, man. Come on.
All right, Judge. Next is
You said paid at 8?
page 8.
Okay. Tatiana Green. Good morning. Ms. Green, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, okay. The complainant and the defendant have been married for 3 years. On November 17, 2024, officers were dispatched to a welfare check at a residence in Harris County, Texas, where the officers met with the complainant, who stated that the defendant and the complainant were having marriage issues due to the defendant cheating. The complainant stated that on November 17th, he observed the complainant laying on the couch, he observed the defendant laying on the couch talking to another man on the phone. An argument then ensued. The complainant stated the defendant grabbed a curtain rod and hit him twice on the leg while he was laying in bed. The complainant stated he called 911 because he was worried about safety and needed help. Just before the officers arrived, the defendant bit the complainant's left arm, causing pain. The officer observed the injury on the complainant's arm.
Do we know if he wants to have contact with her?
I'll read the RIP, but RIP was performed, so.
Okay. Ms. Green, it looks like a protective order has been issued in this case. Get to know it. If you violate it, the state will file additional charges against you. A violation of protective order, it's one of the worst cases you can pick up. Until I know that he wants to have contact with you, I'm barring you from having any contact with this person. Do you understand?
Yes, sir.
So it appears that the complainant does not want contact and the complainant is moving out in order to make sure no contact.
Okay, do you have a child with this person?
No, sir.
Great. I don't want to talk about the case.
It's not about the case. The apartment that we have together is my apartment, but right now, since I got out, I've been at my grandma's.
So for now, right, this bars you from going to the Westmead place, right? So you need a lawyer to represent you in this case. You need a lawyer to represent you in this case, ma'am. Do you work?
I do work. I just started working. Whenever I was in court for like,
You get a lawyer for the magistration.
I didn't talk to anyone.
Okay, so what kind of money do you make a month?
Nothing right now.
How do you support yourself? Okay. Did you want to apply for a court-appointed lawyer, ma'am?
Yes.
The other option is you can go hire one. What would you like? Okay. Actually, I have one. So I have an affidavit already filled out. So what we'll do is I'll have you just sign a reset with Victoria. I'll have you sign here the order for protection, and then we'll have you take a seat. Don't leave until you sign our additional bond conditions, and then we'll have you talk to a lawyer here momentarily.
Okay.
Okay, please.
It was already signed, but.
Oh, that's right. Okay, yeah, we just need to sign the reset, and then we'll have you take a seat. No, come up. Well, no, the deal is that he's moving out, she's moving out.
He is moving out, and he previously told the prosecutor on the case that he has a new place, but I see on the MOAB that it does list the apartment that belongs to the defendant. Yes.
Okay, I want you to go back, but I want to make sure that the person is out first, because I don't want you to go back. He's there and boom, just.
Don't talk about the facts of the case, just talk about this situation. Yeah.
My lease is up on the 7th of December, so I'm okay. I just need to get my personal belongings.
But if he's not living there, Your Honor, I mean.
I just don't know if he's still there.
I can reach out to him.
Do you mind real quick?
Yes, Judge.
Okay, they're going to try to reach out to him real quick to see if he's still there. If he's not, and he's gone.
He's still there.
Until what day?
Until December 2nd.
Oh, okay.
Is he on the lease too?
No, I mean, he doesn't have to leave. I'm with my grandma. I'm okay. I'm okay.
Sure?
Yes. Yes.
Well, is there also?
I don't want to exclude you from your own home.
Is there a no contact too?
It's okay because.
Yeah.
Yes, Judge.
Yes. Did a no contact because he
What's a
doesn't.
no contact?
Yeah.
Yeah.
It's over. Allegedly.
Till next month?
I don't know. You never know. Time heals, right?
Okay, so you're for sure not going back there. He's
I
gonna
can get back.
But what about December 2nd when he leaves? Do you need to go back? You said December 2nd he's getting out of there?
Well, he's gonna communicate with my mom and my sister. That's how we've been conversing.
So let's do this. I'm gonna have Alex reach out to him. At a minimum, let's see when he's gonna go out. That way you have an idea. He's gone and you can go back because.
Well, can your family go get your stuff if need be?
Yeah, I mean,
Probably a lot of stuff.
And the reason we're bringing this up is because if you go to that address
I know.
and he calls the cops,
I know.
even if he tells you, invites you,
Mhm.
even if he's gone,
Mhm.
you will get
I
charged
know.
with a new charge. And I don't want that happening. So if he's out December 2nd is his last day, do you want to come back to court December 3rd? And we can,
I have to remove that residence restriction off. So if you go back, you don't get in trouble.
You don't have to because I'm about to move. My lease is over.
right, but who's gonna
And-
get your stuff out of it?
But it's because it's only right that he lives the rest there because he paid the rent for this month.
Okay, well, I'm just trying to
I
get
understand.
her to get her stuff out without getting in
I'm
trouble.
gonna get it. My sister will get it for me. They don't-
Okay,
Ms. Green, you've got a great lawyer. If you ever need anything, reach out to Greg.
Yes, sir.
Greg knows how to get a hold of me and we can always work something out.
Yes, sir.
Just the worst possible thing you can do is take matters into your own hands, go over there, or because you'll end up picking up a new charge and then things will really go sideways quick. So just please don't. If you ever have any questions, reach out to Greg, he'll always talk to you and yeah, I mean, we're always here as well.
Okay.
We live here. So
okay, so then I'll do a regular reset, and if you need something moved up, let me know and I'll get you here.
Okay.
Okay?
okay, all right, man.
All right,
Am I able to leave?
not yet, I'm gonna give you a reset.
Let's get you the reset and all the paperwork.
All right, thank you, Judge.
Okay, thanks, Greg. Hannah, do you speak English, sir?
Flores José Antonio.
Acérquese aquí al centro. Solamente mire el juez y le contesta con respeto en español.
Claro que sí. Florencio Martinez Vázquez Guillermo.
Guillermo, yes, solo mire el juez.
Charged with driving while intoxicated.
Solo mire el juez, por favor.
You are facing up to 6 months in jail and/or a $2,000 fine.
De dormir.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one, sir.
No, para usted, si usted no puede pagar por su propio. Solo quédese mirando el juez, por favor.
On November 17th, 2024, the officer conducted a traffic stop after observing the defendant's motor vehicle run a red light. Upon contact with the defendant, who was the driver and sole occupant of the vehicle, the officer observed the defendant with bloodshot eyes and a moderate odor of an alcoholic beverage. The defendant admitted to drinking and advised that he was coming from a party. Standard field sobriety tests were performed. HGN, 6 out of 6, walk and turn, 5 out of 8, one leg stand, 2 out of 4. Inventory search of the vehicle reveals 1 open 12-ounce bottle of Modelo.
Drinking while driving?
DICs were read, and the defendant consented to correct. The results being .122 and .126.
Mr. Vasquez Guillermo, I'm going to find that there's probable cause. Tell me, are you a United States citizen? Are you in this country with or without permission?
No, sin permiso. No, without permission.
What happens if you go to jail?
Si usted va a una cárcel. Acérquese, señor, y no me mire, por favor, solo el juez. ¿Qué pasa si usted va a una cárcel?
No, pues, no sé.
Well, I don't know.
Are you in this country with or without permission?
Sin permiso.
O sea, entré con permiso, me quedé.
I entered with permission, but I stayed, I remained.
If you go to jail and immigration finds you, Mr. Vasquez, they will put a detainer on you and you will be stuck in custody until this case is over with. And then you will be shipped off to immigration, where you will sit for another 6 to 9 months waiting for immigration to do whatever they're going to do. I would hope that you recognize it's elementary that you're not to have alcohol in the car while you're driving. And it is a minimum of 5 days in jail to any sentence you get if they allege the open container. I will tell you now that immigration sweeps it every single day. So if you spend more than 6 hours in custody, you'll be stuck like Chuck with an immigration detainer. I'm now putting conditions on your bond. And if I find that you violate these conditions, you will go to jail in a moment's notice. And I don't care if you're kicking and screaming. Do you understand?
Sí, señor, o no, señor?
Sí, entiendo.
You are not allowed to drive. And you will be signing with me today a promise that you're not going to drive. I don't care what your excuse is. If I find that you drive, to jail you will go. Likewise, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you test positive for alcohol or drugs, likewise, you will go into jail.
De igual manera la va a ir a una cárcel. That's fine, that's fine.
Any priority to be eyes?
No, Your Honor.
Ninguno de ustedes. Sonido del juez, por favor. Entienda eso.
Sí.
We are going to reset your case to give you time to hire a lawyer. So I will have you come up here, swear to us that you're not going to drive. This is an affidavit. I'm going to tell you now, Mr. Vasquez, look at me.
Míreme.
This is the only warning you will get from me. One violation whatsoever. I'm going to keep you with me. Do you understand?
¿Entendió eso, señor?
Sí, señor.
Yes, sir.
Okay, coming up here, swear to us that you're not to drive. We'll get you to Victoria, and then we'll get you with Felicia for your bond condition.
All right, Judge, next is page 22, White.
Good morning, Ms. White. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. The complainant and the defendant are married. On November 16th, the officer was dispatched to a residence in Harris County, Texas, in reference to an assault. The officer met with the complainant, who stated the defendant and him had a verbal altercation that began the night prior, due to the defendant thinking the complainant was talking to another woman on the phone. The complainant stated he tried to sleep, but the defendant wouldn't stop arguing. The complainant stated that he slept in a separate bedroom, but the defendant came into the bedroom at 5 a.m. and started yelling at him, accusing him of cheating. The complainant stated he tried to walk out, when the defendant struck him with a closed fist right between his eyes, causing him to feel pain and discomfort. The complainant stated he feared for his life and had no other choice but to call 911.
Okay, Ms. White, I'm going to find that there's probable cause to go forward with the case. Do we know if he wants to have contact with her?
Let me see if a rip has been done, Your Honor.
Please.
No rip has been done, Your Honor.
Okay. I don't know if he wants to have contact with you, so until I know, I'm ordering you not to have contact with this person. A protective order has been issued in this case. I would suggest you get to know it, because if you violate the protective order, the state can and will file additional charges against you, a violation of a protective order, and it's one of the worst cases that you can pick up. Do you understand, man? So you're not to have contact with this person and not to be in possession of any weapons. Do you work, ma'am?
I do.
What do you do for a living?
I'm school bus driver.
What kind of money do you make a month?
$1,000 a month.
Okay, we're going to reset your case to give you time to hire a lawyer. I'll have you go to Victoria, sign a reset. After that, we'll just have you take a seat in the jury box, so we'll get your bond finished, you'll have you sign it, and then you'll be free to go. Okay, please. So no contact, no weapons. Please. You were Aaron Durden?
Yes, sir.
Mr. Durden, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, yes.
Okay.
On November 14, 2024, the officer was on a traffic stop in Harris County, Texas, with emergency lights activated when he heard an engine roaring of a performance motor vehicle and observed the defendant's Lamborghini on the feeder road traveling at least double the speed of moving traffic with a posted speed limit of 45 miles per hour. The officer observed the defendant's motor vehicle swerve in the feeder lanes and enter South Highway at a very high rate of speed without signaling a lane change. The officer terminated the traffic stop and attempted to catch the defendant. The officer observed the defendant's motor vehicle turning into a bar and initiated the traffic stop. The officer approached the motor vehicle and observed the odor of brakes and engine burning from aggressive driving. The officer observed the defendant to be the operator of the motor vehicle sitting behind the wheel and observed a strong odor of an alcoholic beverage and watery eyes. The defendant stated he was coming from Captain Tom's and standard field sobriety tests were started. The defendant then complained he had poor balance, and the defendant fumbled through his wallet trying to find his Texas driver's license and stalled when answering where he was coming from. The defendant was searched and the officer found a receipt from a bar in the defendant's short pocket, and HEN eventually was conducted, finding 6 out of 6 clues. Walk and turn and one leg stand were refused. The D was read the DIC, but refused blood. A search warrant was obtained and executed.
All right, Mr. Durden, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it. That is a blow and go that you put on your car to make sure that you don't have alcohol when you get into a car. If I find that you drive a car that doesn't have one, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, Judge.
I'm also ordering you not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds for you, sir.
Yes, Judge.
Understand that we send notice to DPS in Austin so that any and all officers know if you get pulled over, you're to be driving a vehicle that has an interlock. And if you drive one that doesn't, they will immediately take you to jail. So beware that the all-seeing eye knows. You understand?
Yes, Judge.
We're going to give you time to hire lawyers. So I'm going to have you go to Victoria, sign a reset. You will then get with Felicia for your bond conditions, and after that, you'll be free to go. All right?
Judge.
Okay. Please. Hi, Billy. Jose Antonio Guzman Flores. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The complainant and the defendant are in a dating relationship. On November 16, 2024, the officer was dispatched to a residence in reference to a disturbance. The officer made contact with the complainant, who stated she and the defendant began to argue when she discovered the defendant gave her an STD. The argument began as verbal. The complainant wanted to leave, and the defendant grabbed the complainant's wrist and began to pull her. The defendant then grabbed the complainant's purse, which was wrapped around her waist, and then began to pull her hair. The complainant and the defendant separated when officers arrived. The defendant stated he did not put his hand on the complainant by grabbing her wrist, and pulling her because he wanted her to calm down. The officer observed an injury to the complainant matching her statement.
So you said pull the hair? Is that what you said?
He pulled her hair, yes, Your Honor.
And did you say that it hurt?
The complainant did state that she felt pain.
All right. Okay, Mr. Flores, I'm going to find that there's probable cause to go forward with the case. Do we know if she wants to have contact with him? Yay or nay?
A rip was performed, and let me see real quick.
Take your time. No rush. I don't see. All right, so.
It does not appear she wants contact with the defendant, Your Honor.
No.
No
All right,
contact.
so, and I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Robles as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this court order, the state can and will file additional cases against you, a violation of a protective order, and it's one of the worst misdemeanor cases you can pick up. So just stay away. Don't have contact with her. If she texts you, don't reply. If she calls you from an unknown number, hang up the phone. Just don't have any contact and everything will be fine. How old are you, sir?
22.
What do you do for a living?
I'm a technician right now.
And what kind of money do you make a month?
Sorry?
How much money do you make a month?
$3,500 a month.
And who do you live with?
With my mom.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here. We'll have you sign for the order for protection. I'll have you sign a reset with Victoria. We're going to get you out of here to hire a lawyer. After that, I'll have you take a seat while we get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Okay? Come on. If you can file no contact and no weapons.
Yes, yes.
3,